Welcome to day two of the CASE NCSEA SCI Joint Leadership Summer Series on Disaster Response and Lessons Learned. Our second webinar will be presented by CASE, titled Natural Disasters / Good Samaritan Protection. Thank you for joining us. My name is Logan Akey, and I'm the Coalitions Manager at ACEC. And on behalf of ACEC and the CASE Coalition, I'd like to thank both NCSEA and SEI for being our partners in this second annual Joint Leadership Summer Series, and to our speaker, Roger. We are joined today by our moderator, Don Dusenberry. Don served for 45 years in the Engineering, Mechanics, and Infrastructure Division of Simpson, Gumpertz, and Hagar, Inc., SGH, achieving the title of Senior Principal before beginning to diminish his role. He retired from SGH in 2021, but has remained active as a private consultant. Don has been active in professional organizations including the Structural Engineering Institute of the American Society of Civil Engineers, for which he is a former president of its board of governors. Don is a former president of the board of the Applied Technology Council. He has written and presented extensively on failure investigations and topics such as structural performance under extreme events, including blast, fire, and disproportionate collapse. At this time, I'll turn the floor over to Don to introduce our presenter.
Yes, thank you very much. It's a pleasure to be a moderator for this session. This is a very important series of webinars for people who are interested in helping out after there have been a natural disaster. There were scheduled to be two speakers today, but Leo Argyris has been caught in a travel delay. So our speaker today is his collaborator, Roger Gillen. Roger joined Grayling Insurance Brokerage and Risk Consulting, a division of Epic Insurance Brokers and Consultants, bringing 25 years of litigation and risk management experience to their architects and engineers team. In this role, Roger develops legal and legislative initiatives that are critical to large design firms and the construction community, provides risk avoidance and management consulting to Grayling clients and associates, and supports Grayling's expansion of the ACEC Business Insurance Trust Program. So at this time, I'll turn it over to Roger so that he can make his presentation.
Thank you, Don, and thank you, Logan. It's great to be with everybody this afternoon. I understand we have quite a large audience, and that is absolutely wonderful. And we're all very appreciative that you've taken the time to invest in this program today. As Don mentioned, this is supposed to be co-presented with myself and my partner, Leo Argyris. Unfortunately, he has experienced some travel delays, so he cannot make it. He does extend his regrets. Okay, so what will we talk about today? We're going to talk about natural disasters, man-made disasters, and national catastrophes, and what protections under the law there may be for engineers, particularly structural engineers, when responding in those situations. And when we have this conversation today, it's going to be important to separate or to keep some division between the types of responses where there's no compensation, there's really no preparation, there's no contract in place necessarily, but engineers step up to help out, assess the structural integrity or the safety of a particular asset or area, versus those situations where maybe there is an on-call contract, or maybe there is some type of regime that's already been put in place in case something happens. So we're going to be talking about both of those today, but we're going to be focusing primarily on what we refer to as Good Samaritan legislation. So we'll tee it up by talking about national disasters, many of which are natural or caused by the weather or other phenomena which are completely outside of our control. There will be accidents and failures, unfortunately, with respect to the built environment. And then, of course, equally unfortunately, or more so, sometimes people take things into their own hands to bring about catastrophes, and engineers step up and help in those situations as well. We'll talk about Good Samaritan laws, what they are, where they come from, the types of protections that they provide. We'll talk about the standard of care for an engineer when responding to a national disaster. Does that standard change or shift in any way because it's an emergency? Does it change because people are sort of reacting in the moment and not able to prepare or design or perform calculations versus everything happening on the fly? We'll talk about those implications as well. Who has liability for the actions that are undertaken in an emergency or in the wake of a national disaster? Obviously, we'll talk about insurance considerations. I am from an insurance brokerage. It's what I do. I am a risk consultant, a client executive, and a broker, in addition to being an attorney. So we'll have to talk about the insurance considerations that engineers and firms should keep in mind when they look at this issue. And then we'll kind of summarize by looking at the things engineers should consider before providing disaster services. And at the end, again, we'll have some time for some Q&A. We invite you all to list your questions in the chat. And at the end, Don will triage those and we'll run through Q&A as time permits. So as Don mentioned, my background is, in fact, I'm an attorney. I was an attorney, still am, but I was a practicing attorney until August of 2022, when I left my engineering firm where I was in-house counsel for 18 years to join Epic Insurance Brokers and Consultants, specifically the Architects and Engineers Specialty Vertical, which for 21 years, everyone here has known as Grayling. We have recently gone through a rebranding, and we have parted with the Grayling name. We are now Epic Construction and Design. Grayling was purchased by Epic Insurance Brokers in 2014. It just took 12 years for us to roll up into the broader Epic name and branding. So the same experts, the same specialists, the same team who you may know or be familiar with Grayling, we're all still here. Nothing has changed except the name and the branding. I've been in this industry for, gosh, going on 22 years now, right at 22 years. I practiced privately for 6 years before that. And as you can see, I'm heavily involved in ACEC on a state and national level throughout the country. So I have some experience with structural engineering claims, structural engineering catastrophes, collapses in the wake of national and natural disasters. And we'll build some of that experience into the conversation as we go along. Okay, so what type of disasters can lead to a situation where a structural engineer, other types of engineers step up and in the moment offer their services? Well, obviously, weather and national natural disasters immediately spring to mind. So here you can see an image of the flooding post landfall of Hurricane Katrina. As everyone will probably remember, on September 29th, 2005, Katrina made landfall in Waveland, Mississippi, and devastated points west, primarily New Orleans, Louisiana. Tremendous flooding. Levees failed. The city of New Orleans flooded. Surrounding areas were devastated by wind events, wind-driven rain, and flooding. So when we think about national and natural disasters, things like hurricanes, wildfires, tornadoes, earthquakes, those types of things immediately come to mind. But there are also some structural failures, some accidents, collapses that immediately bring forth the need for structural engineers to offer their expertise. So, and these are not necessarily things we can plan for. So the I-35 bridge collapses in Minnesota under live traffic, completely devastating event. Structural engineers have to step up in the moment and assess the surrounding infrastructure. Is it safe? Is it safe for first responders? Is it safe for the public? How much and where do we have to close this down? There can be environmental disasters, obviously, biological diseases, all manner of things that we do not necessarily expect to happen or plan for that require engineers to step up. When there are catastrophic traffic accidents, I can think of an example in the area where I live, where a tanker, 18-wheeler, a fuel tanker, hit a guardrail and exploded and burnt on an overpass over the interstate, and did significant damage to the superstructure of that overpass. And the overpass itself had to be assessed, had to be closed, and eventually had to be torn down and rebuilt because the interior rebar and other structural members had been compromised so much by the heat of the blaze. When ships collide, run into one another on the open water, or when there are impacts in port, or when a ship sinks, there are oftentimes engineers that have to determine the integrity of port or have to do assessments of the actual vessels themselves. And sometimes that's in such an emergent situation that it's not an on-call deal. It's not under a contract. Aircraft disasters, obviously, they require engineers when they happen, especially if there's any type of implication or impact to an airport, a terminal, things of that nature. And then unfortunately, we do have situations where people bring about these disasters themselves. So Timothy McVeigh decides to blow up the federal building in Oklahoma City. Structural engineers have to come in and assess the situation after the incident to determine, is it safe for first responders to go in? How is the recovery effort going to work? We don't want more people getting hurt. We obviously think of things like 9/11. We think of other catastrophes brought about by human beings, and structural engineers are there to answer the call. So let's talk about a typical scenario following a disaster. So a hurricane has made landfall, or is making landfall. There has been an explosion. There has been a collapse. Usually a team is put together, even in the moment. They're identified and they are mustered to assist as soon as it is safe to do so. So once the hurricane has made landfall and the back wall has moved enough out of the area and the winds have died down enough that it's safe for engineers to go in. Sometimes these teams are pre-assembled. Again, sometimes there's an on-call contract. There's a disaster service on-call whereby a specialized team is ready to respond. And other times, things which are completely unplanned, unanticipated, like a 9/11, take place. And you have engineers who literally come out of their buildings into the streets and offer up their services. What are the protections for those engineers in those instances? We'll talk more about that here in just a moment. So that's an example of an ad hoc situation. In the moments and the days and the weeks following 9/11, for instance, engineers literally streamed out of their offices in Lower Manhattan, offering their services. What can we do? What can we assess? First responders are still in the buildings, have to get back in the buildings. What is safe? Is something else going to be compromised? Is something else going to collapse? That's an ad hoc situation. People are just out of the goodness of their heart offering up their expertise and their services. And then as time goes on following these national disasters, typically there will be some formality and some structure put around these things. Whatever responsible or responding agency is involved, it will start to congeal different teams, different specialists. It will start to put out contracts. And these relationships will get more formalized. A scope of work will start to fall into place. And the inevitable conversation about compensation will need to be had. But in the moment after a national disaster, people aren't generally thinking of those things. Engineers, being good people, being servants, they think, how can we help? And luckily, the law does provide some protection for engineers and others in those situations immediately following or during the occurrence of an emergency. So it's not just structural engineers that respond to these things. There are all manner of specialists, people who are trained in particular areas. So you have engineers, you have architects, you have medical professionals, you have first responders, and many others, all of whom typically offer up their services in the wake of some type of national disaster. Some are licensed and self-regulated, like engineers, like medical professionals, and others are not. contractors. For instance, they're certainly licensed, but they're not necessarily white collar professionals. But they all step up and help out in these situations. Okay, so let's talk about the legal protections that are in place for engineers and others who respond in the wake of some type of national disaster. So we've all heard about Good Samaritan laws, Good Sam laws. We've probably all seen the RVs on the road that have the Good Sam uh, spare tire cover with the guy with the halo and the big smile. What's a Good Samaritan? A Good Samaritan is somebody who really has no obligation, no duty, other than arguably a moral one, to offer oneself up and help in a situation, but does so anyway for the benefit of his or her fellow man. A Good Samaritan is someone who knows they can help, steps in to help when they may not otherwise have to. So a Good Samaritan law, or you'll hear me call it a Good Sam law, is some type of legal protection that has been put on the books by a state legislature to protect those people who step up in the wake of some type of incident, to give them the comfort of mind and the peace of knowing that, hey, if I try to help someone else in the wake of this accident, this car wreck, this explosion, this hurricane, this national disaster, I don't need to be worried that I'm going to get sued for this. Because if people were terrified of being sued every time they turned around, you can imagine how hard it would be to get anybody to be willing to help someone else. So Good Samaritan laws provide some measure of protection for those who step up to help out others in the wake of some type of an emergency. Now, it doesn't cover everything that might happen, and we'll get into a little bit more of that in just a minute. But in terms of just everyday activities, everyday service, everyday negligence, there is protection from civil liability under most states' Good Samaritan laws. And I want to emphasize civil liability because there's typically not protection for criminal liability. And that gets into the fact that intentional acts and willful conduct are typically carved out of the Good Samaritan protection in various state laws. So we have a couple of examples here of language from two states' Good Samaritan laws. And the pertinent parts are shown here, but one very broad. It just says, and I'm paraphrasing, that a Good Samaritan who responds in the wake of an emergency or helps someone else shall not be liable for any damages resulting from their acts or omissions, period. Pretty broad. Doesn't necessarily reference engineers, but engineers are certainly subsumed under that. And we'll talk about that again in just a second. But this is from the state of Georgia's Good Samaritan law. The other one comes from Alabama. It's a little more detailed, but it basically says the same thing. And just to paraphrase, it says a Good Samaritan shall not be liable for any civil damages. Again, there's that emphasis on civil liability as a result of any acts, services, or omissions provided within such capacity if the Good Samaritan acts as a reasonably prudent individual would have acted under the same or similar circumstances. Now, that last phrase, let's put a pin in that because that's going to become really important when we talk about the standard of care for an engineer and structural engineer when he or she responds in the wake of a national disaster. Now, not all states' Good Sam laws explicitly reference or explicitly protect registered engineers. A lot of states' broadly written Good Samaritan statutes have been interpreted by the courts to cover engineers when they respond to national disasters, and Georgia being one of them. We saw the broad language from the Georgia statute just a second ago. But every state has some form of Good Samaritan law. Every state wants to encourage people to be there for one another in the event of an emergency. And so every state has some type of law on the books that says if you render aid and you're not grossly negligent, if you are acting in good faith, if you're not being paid to do it, then you have protection from civil liability for simple negligence And a lot of these laws came about because there would be a car wreck, and maybe there's a doctor or a nurse who witnesses the wreck or is in the area, and he or she immediately responds and tries to help someone who may have been injured in the incident, only to be turned around and be sued because the person either didn't recover or maybe in the act of trying to help, the person inadvertently made things worse. So maybe not knowing that there was a break, but thinking in the moment this is only a sprain, and then there are lingering problems. Well, in a situation like that, a Good Samaritan law would say, wait a minute. Now, under these circumstances, this person was rendering aid, was trying to help, was offering herself up, and may have been simply negligent. But under the circumstances, you can't expect somebody to be completely free from negligence the way they might be if this was a planned surgery involving a patient that they had treated for years, or involving a design of a piece of infrastructure, of an overpass, of a bridge, where the engineer has the time to run calculations, to provide a design, to have back checking and oversight along the way, versus doing it in the moment. So if it's simple negligence, typically a Good Samaritan law will provide civil protection. Now, these laws vary from state to state. They don't all cover the same thing. They don't all say the same thing. They may be very similar in spirit, but an engineer responding to an incident in one state should not assume that that engineer would be treated exactly the same in a neighboring state, because that neighboring state's Good Samaritan law may be written a little differently or may have been interpreted by the courts a little differently. But generally speaking, in order to be protected by a state's Good Samaritan law, there must be no compensation. That's a really important distinction. So that gets back to the first part of our conversation when I said we would have sort of a distinction between those situations where there's no compensation asked or expected or intended. Someone is literally just helping in the moment, versus could be that same incident, but as time goes on and there's more formality and structure put around the response to that national disaster, then the relevant agencies will start to assemble proper teams, retain various types of specialists and engineers, put out contracts, negotiate, and come up with some type of fee. But at that point, that's not a Good Samaritan situation. The immediate response is over, and now we're talking about a more protracted and sophisticated set of services. So in order for there to be good SAM protection, we're talking about a situation where compensation is neither sought nor expected. The engineer must be acting in good faith. So it literally has to be a situation where the engineer says, here's this emergency, how can I help? And nothing more. There can be no gross negligence. So what is gross negligence? It's a legal phrase. Simple negligence is the breach of a standard of care or a duty that is owed to someone else that causes that person to suffer damages. That's simple negligence. Gross negligence is similar to wanton conduct, which is similar to reckless behavior. And that is elevated above simple negligence. And basically what it means is someone either has an appreciation or an understanding that their behavior is likely to cause someone to suffer damage or injury, and they engage in that behavior anyway. So it's not intentional conduct, but it's wanton conduct. It's grossly negligent conduct. It is speeding at a very high rate of speed above the speed limit for a long period of time, knowing that I could lose control of this vehicle and I could hurt my passenger or hurt another motorist, but doing it anyway. It's not simple negligence. It's beyond that. So there can't be gross negligence. There can't be wanton conduct when someone like a structural engineer is responding to a national disaster. But simple negligence will be protected from civil liability under a Good SAM law. And of course, there can be no willful or intentional misconduct on the part of the person providing the assistance. So, assuming all those things are in place, a state's Good Samaritan law would be there to provide civil liability protection in order to encourage and incentivize people to help one another in the wake of a national disaster. So, let's talk about the standard of care that is attendant for engineers when responding to disasters and catastrophes. And in order to do that, we have to have a conversation first about the standard of care generally. So there's 400 something engineers on the webinar this afternoon. Everyone has probably looked at, marked up, negotiated contracts, attended a contract risk management seminar, either with their broker or through ACEC or NICSI or SEI. They've talked to lawyers, they've been to conferences, and we've probably all heard, hey, we need to have a reasonably prudent person standard of care. We need a reasonable, limited standard of care that will judge me as an engineer against what some other engineer would have done in the same or similar circumstances. And that's exactly where we start this conversation. So the generally accepted standard of care is what a reasonably prudent engineer would have done under the same or similar circumstances. So what does that mean? That means a project like this, with a schedule like this, with a budget like this, of this type of nature, meaning, well, hey, this is the design of a completely new interstate, which is going to have 7 bridges, versus a wastewater treatment facility or an airport lighting job. These things are completely different in nature. So what would an engineer do working on a project like this at the same time in the same general regional locale? So maybe it's a part of the country where it's one of the rainiest cities in the country versus out west in a very arid environment. Those are not analogous. The standards are different in designing things in those two respective parts of the country. So what does a reasonably prudent person need to do in this situation? And the phrase "this situation" is really important when we talk about national disasters and catastrophes, because we're talking about a similarly situated engineer. What would a reasonably prudent engineer have done in this situation? So it's entirely unfair in the wake of a 9/11, or in the wake of an I-35 bridge collapse, or in the wake of the collapse of the Hard Rock parking deck collapse in New Orleans a few years ago that killed 3 construction workers. It would be completely unfair to judge the engineers who respond in those situations and offer themselves up to the local agencies to go in and determine this portion of the structure is still sound and it is safe for first responders to go in and search for the missing or to begin the cleanup. It's not fair to judge that the same way we would judge a structural engineer who was working on a project for 9 months and has a team around her and has back checking and the ability to use tons of resources and go through different iterations and bases of designs and come up with concepts and scrap some and adopt others and then pivot the way engineers do in a normal project situation. It's not appropriate to judge that level of care against someone who's responding in the wake of a national disaster. So the phrase that becomes really important when we're talking about the standard of care for an engineer in these situations is the phrase "similarly situated" or "under the same or similar circumstances." And those circumstances are this disaster or a disaster like it. And we would not expect the same level of care, the same level of attention necessarily that we would expect in a normal environment when someone gets to sit in the air conditioning unimpeded. Maybe it's a lump sum job and they're not worried about every tiny little moment. They're able to actually do what it takes to design something, totally different situation in a national disaster. And the law, common law and courts, they recognize that in these situations, things are moving extremely rapidly. There's limited information. There's limited access to information. And these situations are not different from how the news cycle goes following a disaster. The first few things you hear almost universally turn out to be wrong. Things are changing rapidly. So what is understood in the moments following the disaster, those things change. What's understood hours later, they change. What's understood days later, they end up being corrected and changing. So there's limited access to information. The environment, the situation, the understanding, the narrative, everything is evolving very rapidly, all while engineers are trying to help. There can certainly be hazardous situations. There may be an environmental leak. There may be fuel, obviously. There's fires, there's smoke. There's an inability to access the entire site many times, especially when it comes to explosions and collapse or catastrophic weather events like a massive tornado, an F4, F5 tornado, or maybe a large hurricane. So it's impossible to know what's over there because no one can safely access it. It may be days before we get over there. Very hard to judge an engineer for not knowing and appropriately addressing something that no one could even physically access. So these things all factor into how an engineer will be judged if and when someone is to say that they made a mistake or that they were negligent in their response to some type of national disaster. And this all ties back to the age-old ethical canon that governs the practice of all engineering. And everybody knows what that is. It's in the enabling statutes in every state. It's the first ethical canon under the NSPE ethics rules for engineers. And that is to protect the safety, the health, the welfare, and property of the public. That's the first thing. Incidentally, that's why engineers can't owe a fiduciary duty to others, because they owe their duty to safeguard the public. So the ethical ramifications in a national disaster response are really not that different from how an engineer should approach any endeavor. Stay in your lane, core competencies. So if someone is an expert structural engineer, then it's very hard to imagine that same engineer would be competent in something wildly disparate, a totally different disciplinary realm of engineering. So the standard of care requires that engineers stick to their core competencies where they have their expertise. And then in situations where they venture outside of that, that they do that with someone who does have the expertise in that discipline. Document decisions, document observations. In a national disaster, a natural catastrophe, or a man-made event, it's really important to document observations and decisions that are made by the authorities, law enforcement, federal and state, other people who are helping out. These things are very critical because they're all going to change, and they're all going to change very rapidly. And so documenting and observing those things, photographs, diaries, dailies, those types of things, inspection reports become very critical when performing natural disaster services. And of course, communicating to whatever agency is in charge, whoever the quote unquote client would typically be until there's actually a contract and that entity becomes a client. That's really important as well. We are doing this today because we understand the situation on the ground is X, and we have been advised by agency Y that we can do this and we can go no further. Or today's role and scope is simply to determine the structural integrity of this portion of the site for the limited purpose of allowing first responders to go in and do recovery operations. Things like that. Those types of assumptions, those types of instructions should be documented so everybody is very clear on what was happening and when, because again, these things are happening extremely rapidly. And there's really no need to play the hero. The best service is really sticking to what we do best, individually and as engineers and as our own respective firms. What do we do best? That's how I can best help, is I can stick with what I'm good at, and I can do that. I'll do my job. Let someone else who's a specialist in something else focus on that aspect of the emergency service. So there's really no need to play the hero. And in doing so, in playing the hero and overextending, then an engineer in a situation like this can flirt with and kind of skirt up against that line between simply negligent conduct and grossly negligent or reckless conduct. And again, no one thinks that an engineer wants some excuse to be negligent. No one thinks the Good Samaritan laws are there to allow for flippant services or a lack of attention to detail. They simply recognize that in the event of some type of catastrophe, it's just impossible to expect someone to be free of negligence or to provide a service in the same manner that they would under totally normal, peaceful, pre-catastrophe circumstances. So there's really no expectation or a guarantee of a particular outcome in a situation like this. And again, if one avoids reckless and intentional conduct, then an engineer very likely has protection under a state's Good Samaritan laws. So let's talk about who has liability in the wake of a catastrophe or some type of disaster. It's really important to remember that Good Samaritan laws protect individuals or persons. Those are typically the words used in the Good Samaritan laws throughout the country. They don't necessarily protect companies or firms. Now, that's not to say that if an entire firm responded to something, or if a firm told its structural division in Lower Manhattan, everyone get out and see what you can do, then the firm itself would not be protected. It's not to say that, but these laws are intended to protect human beings who step up to help other human beings. So that's important to bear in mind. Now, when we get outside of the initial response to a disaster, where there's no expectation of compensation, and we're talking about the ongoing recovery, the ongoing rebuilding, the ongoing assessment before demolition, and then the politicians will figure out what to do with the site, etc. Now we're talking about getting into a contracting situation between some agency and maybe a firm or an individual engineer. Classic example of a sort of an on-call situation is disaster debris monitoring services. These are very popular in hurricane country, tornado country, where there's some, maybe expectation's the wrong word, but it's reasonable to think that, hey, these things happen enough down here that we need to at least have some type of infrastructure in place that when a storm hits and landfall happens, that on the backside of that storm, someone, an engineering firm, a contractor, someone else is going to be there. We already have a contract in place. We're going to mobilize that vendor. They're going to go out, they're going to staff up, and they're going to help monitor the removal of all of the debris and destruction in the wake of that storm. But that entails compensation. So at that point, we're not talking about Good Samaritan response. Now we're simply talking about contracting, risk management, things of that nature. So if we're in a situation where a natural disaster or some type of national catastrophe has occurred, and the immediate moments following that have passed, maybe we're weeks out, and we're not in a Good Samaritan situation anymore. Now we're in a service situation, and we are under contract, and we're going to continue to provide services on a longer lead basis. Okay, well, I don't have the benefit as a structural engineer of a Good Samaritan law. So how am I protected? At that point, we would just want to engage in sound, fundamental contracts risk management the way we would in any situation. If it's an on-call situation that we put in place with a county, for example, on a disaster debris monitoring, just to continue with that example, then we would simply want a fair contract put in place at the time the on-call contract is negotiated. And then when the task order comes out, we don't have to think about it. But we can protect ourselves through the contracting process, even after the timing and the factual reality of the Good Samaritan situation has passed. Now I'm not seeking protection under a Good Samaritan law. I am a vendor. I am a servant. I am a consultant to this agency, and I have a contract in place. I simply want that to be a fair and insurable contract, and that's the best way to protect myself in that situation. But in the wake of a disaster, and we can think of 9/11, engineers stream out of their buildings, they run to the site. How can I help? What can I do? Put me to work. Is that person responding on his behalf or her behalf? Or is that person responding on behalf of the firm? If there's negligence, well, Good Samaritan law should protect that person. But if for some reason that's not protected, does that liability flow just to that person? Or does that liability flow to the firm? Well, a lot of that has to do with the law of vicarious liability, what the law calls respondeat superior. Is this engineer using the resources of the firm? Is this engineer either using a vehicle, using equipment of the firm, or is this engineer simply out there saying, I'm an engineer, what can I do? Well, it would be helpful if you would go look and see if this part of the building is still safe. We need to get people in there. Go in, do a visual assessment. No time to pull the existing plans necessarily, but you go in, you do an individual assessment, you come back, you say, I think it's fine. That's probably an individual act. But then as time goes on, go back to the office, use the resources of the firm, etc. That's probably more of a situation where that person's acting on behalf of and with the blessing of the firm. Once we're outside of a Good Samaritan situation, if there's negligence involved in the provision of any of those services, we're simply in a situation where if there's an alleged breach of the standard of care, someone can try to hold that engineer and her firm accountable, and we're in a typical claim situation. But that standard of care by which the engineer will be judged will still be critical, because what were the circumstances that that engineer was operating under at the time? Even if it wasn't in the immediate wake of that disaster, what were the circumstances? And what would a reasonably prudent engineer have done in those circumstances? And if the assessment is, well, that engineer would have done what this engineer did, then there should be no breach of the standard of care, and there should be no attendant liability. Well, we can't talk about fun things like claims and potential liability and alleged negligence and breaches of the standard of care without talking about insurance. But the good news is it's a pretty positive picture, even in the wake of a national disaster, even when an engineer is responding to an emergency or a catastrophe. If there's Good Samaritan protection, then hopefully that civil liability is not an issue. But if there is a meaningful or survivable allegation of professional negligence, then even in an emergency situation, professional liability should typically be there to provide coverage. Now, not every possible disaster scenario is automatically covered by PL, professional liability, which I'll call PL. Just like not every design scenario or every possible service scenario could be envisioned or covered by PL, because PL broadly covers damages that the engineer becomes legally obligated to pay due to the negligent rendering or the failure to render professional services. So if there's an actual or an alleged breach of the standard of care by the engineer, then that engineer's professional liability insurance policy will respond to defend the engineer and to pay any damages or indemnity that the engineer may owe. So if post-disaster services are professional in nature, then there should be coverage for that. The fact that it's an emergency should not matter. There's really no emergency exclusion to PL. If there's an emergency, but professional services are being rendered and being offered by someone who's registered and insured under the policy, then if someone comes along and says, hey, I accuse you of having been negligent, the policy should be there to respond. Now, if services are outside of someone's core competency or outside of the scope, then there can be an issue. It's the same conversation we have when we talk about scope of work provisions and the importance of having a limited standard of care provision. Agreements, we talk about this in risk management all the time. You can sign a contract that will expand your standard of care and will give you an unlimited scope of services. Professional liability will not cover every single thing you agree to in a contract. It doesn't just sit over your contract and track your contract. It only covers what it covers. And it's our jobs as engineers and firms and risk consultants and broker partners to craft our contracts in such a way that they comport with our insurance coverage, because it doesn't work the other way around. Now, sometimes there are post-disaster endorsements that can be added to PL if a firm specializes in those things. So there are catastrophe response services, emergency assessments for no compensation. So we're kind of talking about a 9/11 situation, Good Samaritan activities, et cetera. Now, GL is obviously doesn't cover the same things that PL does, because it's there to protect engineers for bodily injury and property damage caused by non-professional negligence. So if a post-disaster activity that is non-professional in nature causes additional property damage and there's no Good Samaritan law to insulate that liability, general liability should be there to respond to that allegation or even the actual negligence. Worker compensation, if an engineer is working on behalf of his or her company and is injured in the process, worker comp should be there to provide protection. And if an engineer is operating a company vehicle or a personal vehicle on company time in the wake of a disaster, and it's not insulated by Good Samaritan law, auto liability should be there as long as the vehicle was insured or the vehicle was being operated on company business. So let's wrap in talking about what engineers should do before a disaster. So preparing in advance. The hours immediately following landfall of a hurricane or some type of disaster should not be the first time that a firm says, hey, should we help? What should we do? It doesn't take very much, but a firm can certainly look at its state's Good Samaritan laws and come up with some type of situation or plan. Hey, if something happens, here's how we will offer to help. If it's this type of disaster, we will go to our local EMA. If it's this type of disaster, we'll work with law enforcement. Just some basic protection, some basic plan to see what it means for that firm to offer itself up. Establish legal, contractual, insurance, and operational frameworks and policies internally around the idea of responding to disasters. Find out how the firm's activities and specializations fit within the Good Samaritan laws in the states where the firm operates or may have an opportunity to provide services. Look at your insurance program with your broker. Make sure that you don't have something hiding in there that would provide a problem if you were to get involved in emergency services or disaster services. Or if you specialize in that, is there an endorsement that would be helpful or coverage that would be helpful because you do that? So in summary, engineers should feel confident in offering themselves up in the wake of a disaster and in times of crisis. All states have some form of Good Samaritan protection on the books to incentivize us to be good citizens, to help one another in times of need without having to look over our shoulders and fear that we're going to get sued for simple negligence if we offer ourselves up. Professional liability provides coverage for engineers as long as the services were professional in nature and we were acting within our core scope and competency. Post-disaster activities have to be performed for no compensation. We have to be acting in good faith. We can't be wanton or negligent. and we have to be free from willful conduct. We will be judged by the reasonably prudent person standard, which we adopted from English jurisprudence at the time that our colonies and eventual country were founded. So the reasonably prudent person standard will judge us when someone alleges that we were negligent. The similar circumstances are whatever the catastrophe happens to be or whatever the situation is. What would a reasonably prudent engineer have done if she had found herself in that same circumstance? That's how we'll be judged. And then the usual fundamental risk management precepts should be applied when we get into longer lead post-disaster services. We want good, fair, insurable contracts with a limited scope of work, with a fair, reasonably prudent person-based standard of care provision, and we want to stick to our core competencies. So with that, Don, I don't know if we have any questions, but in the remaining moments, I'm certainly happy to answer any that we may have.
Thank you very much, Andrew. That's very informative. And yes, there are a couple of questions that I'd like you to try to handle.
Okay,
there were several questions about what constitutes compensation, meaning things like if somebody hands you a sandwich or a bottle of water, reimburses for travel, maybe retroactively pays you. Do those constitute compensation, which then voids a good SAM coverage? And another question about I'm being paid by my employer to be there, or I can put my time on my timesheet. Is that being compensated?
So I'll kind of go in reverse order. I don't believe that Good Samaritan laws look at compensation the way perhaps some ethics laws around the country do, where a sandwich or a bottle of water or a cup of coffee would be prohibited and would certainly consider be considered some type of value or some type of compensation under an ethics law. I don't think that any court would say, hey, look, you received compensation because you were handed water on when you were walking around the area where the tornado went through, or, people came and handed out sandwiches. I don't think that would raise a single eyebrow. With respect to the reimbursement question, I think that's an interesting question. If, let's say, there is a national disaster and an engineer goes out and helps and does not request and does not receive compensation, and then 6 months later, that agency says, or the engineer says, hey, I want to talk now about getting compensated for all the work we did after landfall of that, Category 5 hurricane. I think in the event that there's reimbursement for what were originally assumed to be disaster response services, gratis, and if a claim comes in that says, well, when that engineer helped and did that visual assessment of this structure and told the fire department that it was safe for their people to go in, but then it collapsed as soon as the first firefighter went in there, and that family now wants to sue. If there's reimbursement, I think there's a pretty strong argument on behalf of that firefighter's family to say Good Samaritan law doesn't apply, because even though they were responding in the time of the situation and they didn't get paid at that time, they were compensated. Whether that argument would prevail in front of a judge, I can't predict. I do predict pretty strongly that that argument would be made by the plaintiff's lawyer. And so if we're talking about a true Good Samaritan situation, even if that then evolves into a long lead contractual situation where there's going to be compensation, I would leave that initial response, whatever it is, whether it's days or weeks, I would leave that out of the compensation and truly treat that as a Good Samaritan response scenario. Not just because, well, maybe someone's going to come crawling out of the woodwork and bring a claim or a lawsuit, but it's certainly a goodwill thing. If we think about the capital involved and the value of the goodwill of not just our engineering firms and their names, but our stamps and our seals, Um, and then if it were to hit the newspaper that Acme, um, who was praised for its response in the wake of Hurricane Joe, uh, turns out has gone to the county commission and has sought compensation for everything it did from the moment the storm hit. I think the goodwill would be so negative that the reimbursement's probably not worth it. Whether you're paid by your employer to do it, that is a fantastic question. I don't know that I know the answer to that question. I interpret the Good Samaritan laws to say that if you're not compensated by whoever you're offering your services to, so maybe that's the EMA, maybe that's the Department of Environmental Quality, maybe that is the State Port Authority. As long as they're not compensating, I think that's okay. It's an interesting nuance, and I'll just be perfectly candid. I don't know the answer as to whether if someone says, I'm here to help, but they're being paid by their employer, whether that's Good Samaritan protection or not. You think about the classic example where a doctor or a nurse leaps out of their car at an intersection when there's been a bad wreck. Well, they're typically off the clock, so they're not being compensated by anybody. But if it's in the middle of a workday and there's a catastrophe and structural engineers come out of their buildings and offer to help, well, these are salaried people. They don't punch a clock. They're paid if they're working. I would think that would not destroy the protection as long as the agency or the public entity or whomever that we are offering ourselves up for are not the ones compensating. I think it would be okay. I would at least make that argument in court.
And that's the next question. None of this frees you from appearing in court either as a defendant or a witness or anything like that, right? You still go to court if someone feels aggrieved and wants to hold you responsible. You don't get a free pass. Is that correct?
Yeah, Don, whoever asked that asked a really great question, and it's very true. Good Samaritan law, like an effective anti-indemnity statute, or maybe even a full-blown immunity statute, like in a place like Florida and Alabama, they have CEI immunity statutes. I wish that those were force fields around engineering firms, whereby if someone made the allegation, they would just bounce off because of the existence of these statutes. Unfortunately, that's not the case, and the person that asked that question is very astute. It kind of brings to mind that age-old slang. You can sue a ham sandwich. You can sue anybody for anything. You can certainly be sued. The best case scenario is that these Good Samaritan laws are on the books, and we, at least under the due process, that is inherent in our constitutional republic, we have the opportunity and the right to go in and use these statutes to defend ourselves and say, I can't prevent you from suing, but judge, you have to throw this out because this statute provides me this protection and I meet these elements. I fall under these qualifications. I didn't receive compensation. I was simply negligent, or I wasn't negligent at all. I acted in good faith and I did not engage in willful conduct. So judge, throw it out. The good news about Good Samaritan work is that's a pretty sympathetic defendant. If you think about a natural disaster and then you think about an engineer who offers herself up, and then someone hauls them into court, I think most judges would be rather sympathetic and try to find a way to not only let that engineer out, but also to send a message that, hey, we want to incentivize people to help one another and not be afraid of being sued and having to live in court for the next 18 months.
I know you haven't spoken about being licensed in the state where you are providing these services. Say you're driving across the Midwest and you come across a tornado wreckage and you're not licensed in Kansas. Are you in trouble with the Board of Registration in Kansas?
That is a fantastic question. I think that if you are a structural engineer, and you're not licensed in a particular state, and there is an emergency situation, and you go to, the representatives of the agency who are on site. Let's just say it's the EMA, and you say, "Listen, I am I'm a structural engineer in Iowa. I'm not licensed in Kansas. I'm here with my family. We heard about what happened. What can I do to help?" Um, I think that under those circumstances, as long as someone is not designing something, stamping something, sealing something, but maybe we're talking about doing just a rough visual assessment, I think that it would be unlikely that someone's going to come along and file an ethical complaint to challenge that service. Now, obviously, if someone says, "Look, I'm going to do all these calculations and I'm going to help you come up with a temporary surface for this bridge that is partially out so the first responders can get over here and to there," can't stamp it, can't seal it. Uh, I think what I would recommend if someone in the audience is in a situation like that would be to ask, someone at the EMA or whoever else is on site, is there a registered engineer here on site that's also here? And then go to that person and say, "Hey, I'm licensed in Iowa. I'm not licensed here. You're licensed here. I'm going to work under you on this. Cool." And then have that person say, "Yeah, absolutely. Now you're under the responsible charge of a properly registered engineer, and everything should be fine." I cannot imagine a scenario where someone would challenge that as unlicensed practice, unless it truly was some type of situation where, that activity led to something worse. And then someone's going to say, "Well, why was this advice given? This person's not even registered." But that's typically not what happens in the waning moment, in the moments following a disaster, which may be hours or days. Once we get out of that and the echo of that catastrophe has kind of faded, we're more in a contracting, a more formal situation and relationship with that agency. And then, of course, that person would either not practice in that state or would make sure that that person was under the responsible charge of a registered engineer in that state.
I think we're just about out of time, but there were questions about whether your slides will be posted anywhere for people to access.
I'm happy to do that. So what I'll do is I'll provide a copy of the presentation to Logan, and then I'll let Logan, on behalf of CASE, distribute that to the other partners at NICSE and SEI, and they can make sure that whoever wants a copy can receive it.
Okay. I think that's it because we are out of time, and I think we need to close at this point. So Roger, thank you very much for your presentation, and to the three organizations for collaborating to put on this webinar series. And I hope the audience has learned some interesting things today.
And I want to thank all three organizations for inviting me to do this. It was a lot of fun. I enjoyed presenting to everybody. My contact information is on the screen, so take a picture with your phone, screen grab, whatever the case may be. Happy to talk to you further about this or any other issues that I can help with. Thank you so much.